Everybody say, ah. Say, oh, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana.
Hello, lovely people out there. The community is ready and the law is right next to you. What do? We need to link the two, and it's live on BWTV. The community and the law is next, and this afternoon we're going to look at some practical ways of getting things right when it comes to your application for your stay here in the UK. Switching from skilled worker visa to a family visa, that is a spousal visa. How to get it right the very first time. This will be very beneficial to you. So I would entreat you to call somebody, for the other person to call the other person, and let's all get ready together in the community to have the discussion on the law. My name is Oreku Frimpon, and we're coming your way courtesy BWF Solicitors. Let's get into this together.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And welcome back. Thank you for your time. It's another Saturday afternoon where we meet together in the community to discuss the law. And we do that courtesy BWF Solicitors. This afternoon, we're looking at switching from skilled worker visa to a family visa, that's a spousal visa. And we're going to look at how to get it right the very first time. My name is Oreku Owusu-Frimpong, and I am doing this together with my resource person and guest from the fold of BWF Solicitors, lawyer Charles Asma is my resources person and guest, as I said earlier on, and we're going to have that discussion. He will be taking us through some of the updates we have, and then again lead us into how we can get that application done very correctly and doing it and getting it right the very first time. Pick up the link, share, and invite others to join us, because it's going to be a very good afternoon for all of us. It's a bit windy, cloudy outside there, but in here we have the warmth, we have the knowledge, and we have the experience to share with you. So let me first of all quickly go to the desk of lawyer Charles Asma to say welcome to him, get him to do the traditional greetings, then we'll pick up the updates. Lawyer Asma, good afternoon.
Good afternoon, Bragoku.
How are you doing, sir?
Very well. How are you too?
Yeah, I'm good. Happy to have you again. And on behalf of my numerous viewers, listeners, and clients, we want to say thank you, and thank you again.
Thank you. Pleasure to always serve the community.
Right. Okay. Now, we with you. I know you have your tradition. You would want to say your good afternoons to people and your warm welcome. So yeah, over to you. Get to do that, and we go to the updates.
Thank you very much, viewers and listeners. A very good afternoon to you wherever you are. We have met again. Greetings from BWF Solicitors. Today is a wonderful conversation. Stay glued and let's have fun together.
All right. Well, thank you very much, Charles. We are going to pick up certain things that BWF Solicitors, you guys have put out there for us to really chew on, and that's for our nuggets. But before then, this is the first weekend in September, I should guess so, and we're going to look at what we did in August 2024. Employee of the month is our brother Emmanuel Ampiao from Accra office. He's a legal assistant at BWF Solicitors in the Ghana office. Emma, congratulations to you. Thank you for all you do. our viewers, our clients, our customers, and everybody in the family appreciate you. And we want to say, keep it going. You have won the prize of the Employee of the Month of August. And together we say, congratulations and thank you for doing what you do. Thank you very much. And I believe you share the prize with me. Anyway, we go to what our clients are also saying. We are appreciating people within our clients from outside are also appreciating us. Now let's hear this from Papa Phil. Papa Phil says that Pamela did a great and a wonderful job concerning my daughter's visa application. I've never met anyone as patient as her. Thank you very much, BWF solicitors. I will always recommend you to anyone who requires your service. Yes. So if you come in and you have that good experience, share it with others. Let everybody know that BWF solicitors sit on top and they provide good quality service. So bring all your needs, legal needs, I should say, to BWF solicitors. You can call BWF solicitors from Monday to Friday between 9:30 and 6 p.m. in their offices on the number 0208 493 7340 0208 493 7340, or you can call the emergency number 077 127 61884 077 127 61884. It's a UK mobile number. You can send your text and WhatsApp to that, and we will attend to you. Now, the update. Now, processing standard time reduced for marriage and family entry clearance cases. Now, in a communication to stakeholders sent on the 30th of August 2024, the Home Office has announced that it will introduce shorter processing time for marriage and family entry clearance applications, bringing the service standard down from 120 working days to 60 working days. That is the half in the time. The announcement states that a service standard has been amended to reflect what has been happening for some time in practice. This was catered from the Case Work Guidance Visa Processing Times application outside the UK, 2nd of September 2024. We're moving on. I think we will get Laura to highlight that, but the nugget. We have heard that some marriages are not recognized, some are, and we want to know the difference. Married but not married. If you are faced with a conundrum, what is happening? Now, asking why your church wedding may not meet the requirements of a valid marriage in England. Why is that so? Religious marriages or ceremonies are only valid if they comply with the strict requirements of the Marriage Act of 1949. The Church of England is the only religious body whose own buildings, ceremonies, and celebrants are automatically qualified to create and register opposite sex marriages. All other churches and religious ceremonies must involve an additional civil element, and the place of worship may have to be separately registered to celebrate valid marriages. This was from the case Attorney General versus Acta and Khan of 2020. Well, with this, let me quickly go over to the desk of lawyer Charles Asma again and ask. We know people go to churches, they celebrate their marriages, but you guys are telling us it may not be recognized. Why is that so?
Thank you very much. We have to understand the context first. Every marriage is a marriage unless and until it is to be debated or contested. Why will your marriage be contested, whether it is valid or not valid? That is when you are using it for official purpose
Mm-hmm.
to obtain a benefit. If I say benefit, I don't mean public fund benefit, but benefit in terms of letting authorities know that you are married and therefore anything accruing to the marriage must be accredited to you. For example, you are going to declare that you are married for immigration purposes.
Mm-hmm.
Then we have to look at the context, whether this marriage is valid or not in the UK context.
Okay.
So the starting point is that we know that UK government is position is that if the marriage is recognized abroad, then UK will recognize that marriage. For example, if you married abroad within the context on the validity of the country where that marriage is contracted, the marriage laws of that country, if that marriage is recognized, UK will recognize it. What about marriage in the UK? That means it is not a brainer. If you are married in the UK, then the marriage should be recognized in the UK for UK to recognize it. Is that not it?
Yeah, it is.
Therefore, we are looking at a marriage that is within the church context,
Mm-hmm.
hence wedding. Wedding is a church context marriage. So the church performs the ceremony, blesses the marriage, and it is declared you are given a certificate. The question is this certificate valid? Is this certificate from this church valid within the validity assessment of marriages in the UK? Then we are looking at the religious context of marriage. So this nugget is saying that if the marriage is celebrated within a church, the only church that is allowed or whose marriage is recognized is the Church of England.
Okay.
So if you bring it from the Catholic Church, you bring it from Pentecostal church that is operating in the UK or any other church operating in the UK, that might be contested because one, that is not coming from Church of England. It says that all other churches and
Mm-hmm.
religious ceremonies must involve an additional civil element, and the place of worship may have to be separately registered to celebrate valid marriages. And therefore, the first question is this church licensed to officiate marriages in the UK? If it is not licensed, then that marriage will not be valid within the context of marriages in the UK.
Okay.
Number two, has all the processes been carried? That's why I'm saying that if you are married in the UK and you are not using the marriage for anything, nobody cares anyway. You can even live without marriage. But the
Okay.
moment you are declaring that this is marriage, and for that matter, anything accruing to marriages should accrue to you, then you have to show that this marriage is valid in the UK.
Okay. So I'm looking at the scenario where somebody goes to the local authority registry, marries there, registers the marriage, and goes to church to celebrate it. Is that allowed?
So you are talking about two things. So the first thing you've mentioned is that a person has gone through the processes within the Recognized Marriages Act in the UK to have
Mm-hmm.
the marriage certified by the local authority. Local authority has marriage registry within its setup.
Mm-hmm.
And that local authority will ensure that the law is complied with, including the Marriage Act of 1949.
Mm-hmm.
And so once the boxes are ticked and the government has given you a certificate of marriage through the local authority, that is enough.
Okay.
And therefore, if after that you go to inform your church members and your church leaders that you are married, that is just a ceremony.
Okay.
It shouldn't be the other way around,
Okay.
where the church has celebrated or officiated that marriage and has given you a certificate, and you are telling people or the world that this is my marriage.
Okay.
Then the law is saying that that will not be a valid marriage because the church will have to then prove that they have the license to officiate your marriage and to give you a certificate of marriage. So that certificate the church will give you
Mm-hmm.
will be a certificate for church purposes or for that local context purpose, but not the national context as in the UK. So if the question you ask, if the person has married within the local authority and has marriage certificate, why would they go and get another certificate from church? So that church certificate will not be used for anything. It's just for to
Anything?
decorate your.
It's just for the sake of it, maybe just to let
It's
people
just to
know.
please,
But then
just to
my question then would be, in the nugget, it says that all other churches and religious ceremonies must involve an additional civil element. Where does this come from? Does the church go to the local authority to register and get a license to say that I, the priest of that church, should be given the license to um, declare marriage and even get people together to marry? Is that what is done?
So if the church wants to be recognized
Mhm.
in terms of officiating marriages and issuing marriage certificate, then
Valid marriage certificate. We
well,
must know.
once the church is recognized to do that, then
Hmm.
it is presumed that such certificate will be valid in the eyes of the law in the UK because you've
Okay.
gone through the process, the other elements to
Hmm.
have you recognized. So, question one: have you told the authorities that your place of worship can be used to officiate marriages? And what are the criteria or whatever checklist given to you to ensure that that is um, conformed with? You have done that. So the
Hmm.
place, what sort of place? So the local authorities, yes, so you have to apply to the local authority. The local authority will go through all the processes because at the end of the day, the church is within a particular local authority. And if you want, apart, why do we say that the Church of England is the only church that is recognized automatically? The Church of England is the only church owned by Great Britain, isn't it? And therefore its marriages are recognized automatically. And therefore, if you want yours to be recognized as such, you have to go through the process. So you have to make a formal application for a license. You have to then show that the priest or the pastor or the reverend or whoever is going to officiate marriages is licensed to do so in terms of whether they have the necessary qualification to be able to officiate marriages or whether they can be accepted to be ministers of religion, so to speak. Again, the place or the setup and all the necessary things. Again, they will ensure that before anything is done, certain customary processes have also been followed. And so, once you have a license that allows you to do that in the UK, then just like Church of England, yours will be recognized. But at the moment, there are not many churches in the UK that have gone through such processes. And therefore, if you marry in a church by way of a wedding, and you are using that certificate for any official purposes in the UK, the question would be, is this church authorized to give you marriage certificate? If the church is not authorized, then you cannot use that certificate for official purpose in the UK.
Right. This whole marriage thing. I would want to really go back into it and ask the question that I get my traditional marriage done, the customary one. I get it done. I come here into the UK and I get it registered at the registry. The church blesses it. Am I overdoing things if I look at it that way?
I will ask you, what is the purpose of doing all this?
Hmm.
If you are doing it just to show that you are married, it's fine. If you are doing it so that your marriage will be recognized in the UK for official purposes, and I stress official purposes, then it is important you do so. So you attend, let's say, a particular church. Yes, you'll be married in that church. The pastors in the church will officiate your marriage, bless and give you a certificate, or not give you a certificate at all. Whether they're going to issue you a certificate or not is not the point. The main thing is the marriage is the wedding has taken place. Do you need a certificate to show that you are married? Of course, most of the churches will give you that. Most of the churches will have the standard marriage certificate. But it may be the case that the church doesn't have official license to officiate a marriage that will be used for official purpose by the couple. So, if you are married, we are not saying that your marriage is not valid. Your marriage may not be valid if you are using it for official purpose. For example, for immigration purpose. So, you bring a certificate from your church and you add it to your application. We are married. This is the marriage certificate. That is where the caseworker will say that, hang on, we see that the marriage was, so the wedding took place at this particular church. This particular church is not a recognized church in the UK. This particular church is not recognized or licensed to conduct marriages in the UK, and therefore this certificate will not be valid. And if the certificate is not valid, then the marriage is not valid in the UK, full stop.
Okay. Whilst we are on, that's the beauty of the BWF Solicitors family. Lawyer Asma is our resource person, I guess, this afternoon. I still have Lawyer Bernard Usu, Uncle Ben, who is a member of the family panel. Lawyer Ben, let me ask you this. I'm looking at the nugget we had and the issue of marriages. Now, as a member of the family panel, your perspective of marriage, this wedding bed, and the religious or the marriages and the ceremonies, where do we stand? Where do we have the dichotomy?
Oh, okay. Well, good evening to you.
Yes, good evening.
Good evening, Charles, and good evening, listeners, and those who join us on TV. This is a very contentious and emotive issue for me because, we have dealt with cases where a relationship of a marriage of 15 years ended up in court, and the court said it wasn't marriage. I have been involved in similar cases before, and that is why it was our main topic on Thursday, and also as part of our nuggets this week. First of all, both in Ghana and in the UK, and last week in Ghana, a lawyer wrote an article about the same issue. Mm-hmm. But there are many people in Ghana who are walking around with purported religious ceremonies purporting to be marriages, which are not marriages, and they are not married. So for me, there are two things that I'm looking at. I'm looking at the children. I'm looking at death, where somebody dies and there's no will, and the person dies intestate, and under intestacy rules, is the spouse who inherits. And for want of a better word, the purported marriage ends up being a non-marriage or an invalid marriage.
Okay.
So that is why we're treating this topic. First of all, as Charles clearly pointed out, in the UK, the only religious marriage which is recognized, one is the Church of England, two is a Quaker, which is a religious sect, and three is Jewish marriages. Any other Christian marriage which takes place in a church environment is only recognized if the extra registration and the civil part has been complied with. Okay. So, for example, if I've got a church, say Nanawusu Aladula or Nanawusu Baptist Church, my church may be recognized as a designated place of worship. But the second part, which is a designated place of solemnization of marriages, may not have been done. The second part is that the minister who purportedly conducted the ceremony is not licensed to do it. So Charles is a lay preacher. He's a lay pastor. And I've always had this issue with the pastors, and I've advised them that first of all, somebody comes to you and say, I want to do a wedding in your church, you must let them know that it's not a wedding, it's a blessing. I'm not talking of Bible. I'm not a Bible specialist or expert. I'm a lawyer, a specialist family lawyer. So I'm not talking about Bible. I'm talking about law. And in this country, if a church, Nanawusu Baptist Church, conducts a ceremony purportedly giving a marriage certificate that is invalid, and we're not serving the community well if that's what we're doing. So how do we resolve this problem? I propose two solutions. If we still want to go ahead and do what we're doing, do your customary marriage in Ghana. Bring it to the UK. Tell your pastor I've done my customary marriage. The pastor will then bless your marriage. If you want to tell your friends that that ceremony is a wedding, that's a matter for you.
Mm.
The second part is for the churches to register their churches and register the ministers to be able to conduct this. The Quaker religious body have done it. If the Jewish religious bodies have done it, we as Ghanaian churches should be able to register our churches as a designated place of solemnization of marriages and then register our ministers. You can do that through the district superintendent registrar of marriages. They will do the registration for you. So that is why we're treating this topic. We don't want years down the line parents walking into our offices and say, lawyer, this is my marriage certificate from Nanausu Pentecostal Church. And then Nanausu tells you, no, I'm sorry, it's not a marriage. And that's why we're doing this topic.
Okay.
So
I was going to pose this question once you're on, maybe Charles, let me quickly while you join us and pose this question to Uncle Ben. What do I look for, or what do I ask from my local church and pastor to be satisfied that what I'm going to do in the church is valid and will not create problems for me down the line?
Okay, so there are three questions which I said on Thursday. There's a video which will be out next week, giving clarity to all this. The first question you asked is, Pastor, are you licensed by the British government to conduct marriages? Because if you say, are you licensed, of course, he's a pastor. So of course he will be licensed. But are you licensed by the British government, by the marriage registrar to conduct marriages? Two, is this place a designated place of solemnization of marriages?
Mm-hmm.
And the third one, have we given notice or bans, B-A-R-N-S, bans to the public? If all these three are yes, 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 then you can go ahead. As I speak to you, there's a young woman in her early 20s who is going to go through a ceremony next year. She's invited all her friends. I needed to advise them that what she's doing is not valid marriage. She didn't know. Nobody told her. And these are the problems that we're having in our community, and that's why we've raised it.
Okay. So at least be sure that the priest is permitted and allowed by the British government. Two, the place is a designated place of solemnization. And then we have had the bans or the announcement made to the public that such a ceremony is going to happen. With the bans bit, how many days or weeks notice should be given?
Under our marriage rules, it's usually a month. Sometimes you can shorten it because there are always emergency marriages. But the bans are published by the local authority through the superintendent registrar.
Okay. Right. Uncle Ben, thank you very much for adding to this bit of the discussion. We really appreciate that.
You're welcome, Kweku. Thank you very much.
Okay, thank you very much. Mr. Bernard also is a senior partner of BWF Solicitors, a member of the family panel, and, well, of course, our boss. So, Lawyer Charles Asma, myself, were discussing that. He came in to contribute. So I'll go over it again as to why your church wedding may not meet the requirements of a valid marriage in England. Religious marriages or ceremonies, as we have said, are only valid if they comply with the strict requirements of the Marriage Act of 1949. Earlier, Lawyer Charles Asma explained to us, and was also supported by Uncle Ben, that the Church of England is the only religious body whose own buildings, ceremonies, and celebrants are automatically qualified to create and register opposite-sex marriages. All other churches and religious ceremonies must involve an additional civil element. And remember, Uncle Charles mentioned that. Uncle Ben also supported it. And the place of worship may have to be separately registered to celebrate valid
Thank you very much. Yes, so Brakoku, good. So I think it's been clarified, and once you have Supreme Court ruling, the lower courts don't really add much, and so the senior partner has summarized the point, and the key things are there are family connotations and also immigration connotations.
That's right.
Whether
Yeah.
you are going to use it for immigration purposes or you are going to use it for inheritance, family aspect, and all those things, the most important thing is the marriage valid in the UK. So what we are taking away is that if you are getting married in the UK and you are not going through the council itself to register it for you, and you are using your local church, ask yourself, after doing this, can I still say that I have married and therefore any official conversations that may come up, be it property matters, inheritance, be it immigration matters as a spouse or whatever, can I rely on this marriage? If you cannot be sure, you have to do your due diligence or homework before you take that step. Otherwise, that marriage will just be a ceremony, and as was pointed out, and we have already stated, it will just be a blessing and not a solemnization. So that's the difference. Now, in terms of the time frames, the standard time keeps changing. And yes, before they said 6 months, and it went to 9 months, it went to 12 months, and now they say there's no limit, so anytime at all. But we know that entry clearance applications, and as the update states, entry clearance. So with entry clearance cases for spousal applications, usually they don't take that long. So within 2 months before you have your decision, it went to 4 months. It's back to 2 months within which we can have the decision for that applicant. And so the good news is that if we're applying from abroad, and that is why we say entry clearance, if you're applying from abroad, give and take, if you're estimating your time, you can use 2 months, which is 60 days. But it says 60 working days. That means if you have a month with 4 weekends, and we are talking about 2 months, then you are looking about 8 weekends. And with those 8 weekends, you have to add to the 60 standard days, which now becomes about 68 to 70 days. So let's bear in mind. Don't say, oh, they say 60 days. It's 60 working days. So let's be mindful. However, this is a guidance or a note issued to us that caseworkers must follow. And therefore, it is advisory. At a point, they can say that, well, yes, the note was advisory and therefore not binding. And so if it delays, we can only go back to them and say, hang on, you said you do it within 60 working days. How come it's been about 70 working days, 80 working days? That is where we push for the PAP or pre-action protocol, or telling them that there has been unreasonable delay. They always come back and tell us that, yes, they recognize that and therefore they have operational issues. There are instances where they will give you notice that we said 60 days, 60 working days, but due to operational challenges, your decision will not be available, or you will not receive a decision until some other days or some few extra days. Then you are already aware. But give and take is good news. Time is halved, which is something to celebrate, and a relief for families that are making entry clearance applications within the family migration provisions.
Yes, so trust BWF solicitors whenever an update drops. they will get it first. We just a few days into September, and this came at the end of August. That communication was sent to stakeholders on that day, and the Home Office announced that it was going to introduce shorter processing times for marriage and family entry clearance applications. It's been halved from 120 working days to 60 working days. And I like the caveat that Lawyer Charles has added, that if we are looking at working days, so consider the weekends that will fall within the period. It's all about the community and the law. Now, look at this. I will be asking you a very interesting question based on the nugget we had, the explanation that Lawyer Charles and Uncle Ben have given us. Married but not married. Let's check this scenario from one of families here in the UK. Amma Grace and Kofi Brookman had a religious wedding at Aquinas Charismatic Church at Cricklewood, London in June 2015 on unapproved premises under the Marriage Act. There was no additional civil element involved, and the place of worship was not registered under the Marriage Act of 1949. They subsequently had 2 children and bought 2 properties together. In January 2023, Amma filed for divorce and financial settlement under the Matrimonial Causes Act. Let's put ourselves in the shoes of the lawyers. Advise Amma whether her application will succeed. Is it one, as Amma was married in a church, she can file for divorce in England? Is it 2, as Amma's marriage was conducted in an unregistered place of marriage, the laws would not recognize her marriage as valid? She cannot file for divorce? Or 3, Amma can make the application because they have 2 children and 2 properties together. Think about that. At the tail end of the program, I'll bring it back and we see which of them will be correct, and I'll test you to find out whether you got the answers correct or not. With that, I want to say thank you to BWF Solicitors, and we give you their message, show you where they are, tell you what they do, and when we come back, we're going to go into the classroom. You know, every time I have Lawyer Charles Asma here, it's like I am with my Professor Ahmad, my teacher, because he does that methodically, takes us through the steps, and we're going to look at switching from skilled worker visa to a family visa or a spouse visa, how to get it right the very first time. It's a community and the law. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much. Welcome back. This is the Community on the Law, and we're doing that courtesy BWF Solicitors. And we're going to look at switching from skilled worker visa to a family spousal visa, how we get it right the very first time of applying. My family online, either on YouTube, Facebook, or the social media platforms, let me welcome you and say thank you for being there. Tilly Duma, you're there. Abigail, you are there. Rebecca Amako, thank you very much. You asking everybody to respond to the greeting. Yes, good afternoon to everyone. PSA Nanado. We also have Patrick Amoa. Hi, boss. You're doing a great job. Keep it up. Thank you, Patrick, for also sticking around. For you, we do what we do. And as some of my folks will say, for God, country, and survivor. Now, if you join us either on Facebook, YouTube, or any social media platform, live on TV, BWF Solicitors, BWTV, just let us know you are there. Announce yourself. Put your presence in the comment section below. If you have any question, you can text us on 0739920848 or send a WhatsApp to that same number 0739920848. And when the lines are active, you can get us on the phone 0208 493 7345. 0208 493 7345. Yes. And I would want to mention that whilst we're saying thank you to BWF Solicitors, we say thank you to Lawyer Charles Asma, who is spending his afternoon with us today to discuss switching from the skilled worker route to a family visa or a spousal visa, sorry. Why from skilled worker visa to a family one? You remember last week, if you were with us, Laura Eunice took us through what happens when you switch from the graduate route to the skilled worker route, and when the graduate route does not really count to your indefinite leave to remain here in the UK. So now let's look at the skilled worker route. Why would we switch from that to the family route? What happens? And who can do that? How do we do that? Asma, we have all these questions and we have come your way.
Thank you very much, Brakoku. And once again, good afternoon to viewers and listeners. This is a community engagement, and we share information that will empower you and to assure you. Much as we are not promising, but we are confident that the advice will be helpful to you. Those who have followed the advice have benefited from it. And therefore, today, you see, when you are in a classroom, there's something called previous knowledge, what has worked before, and we are going to add to it. And because we're looking at how to get it right, we want to see whether it has we have gotten it right before. There's no point telling somebody that this medicine works if you haven't tried it yourself or it hasn't worked for somebody. And so we are telling you what we have tested and what we've tried. So, what evidence do we have? Then we tell you how we got the evidence. Producer, please, if you're available, share the redacted decision. The redacted decision, please. Thank you very much. Brother, could you please read this with the date, where it came from?
It says, dear, in our parlance, dear Asumesi, immigration advisor reference.
Where it came from. The date.
It says from Home Office Atlas. So and it's addressed to you, Asma?
Date.
And the 13th of August, 2024, 14:19 hours afternoon.
Application update, right?
Yes.
Okay.
And it's an application update, yes.
Good. Please go ahead.
It says the SMSC reference that please sign enclosed a decision relating to your client's application for permission to stay in the UK. Please ensure that this is passed to your client immediately. And it continues to write the letter, dear, your application under the partner FLRM route of the immigration rules has been successful. You've been granted permission to stay in the UK until February 17, 2027. This notice sets out all of the conditions of your permission to stay in the UK. So please read it carefully. Your conditions.
Okay,
The-
all right. So
okay.
we don't really need the conditions because that is something that so steady work and these are all just like bicycle. Ukosi kukuswa are free, so free ride. But the key thing is the person's application succeeded. So let's go back to application is successful. And this is what we pride ourselves in as a community lawyers.
Right.
We try it works, and we tell you that it has worked before, and this is how to go about it. So, how did we do this? What is the context? So, we bring you topics that are relevant, that are workable. This is somebody who came to the UK as a skilled worker migrant. Whilst in the UK, meets a lover. They start a relationship, they marry, and she decides to switch so that she will no longer remain as a worker for somebody, but as a partner for her husband.
Okay.
And this is the outcome from the Home Office that following the assessment of your application from your lawyers, you have been granted leave to remain under Appendix FM. So we are saying that how do you get it right? This is for the first time she tried it, it worked. So you come as a skilled worker. That is governed by Appendix skilled worker to the immigration rules. So you show that you have a relationship. You show that you are working, you have an employer, blah, blah, blah. It's all COS related matter. And so the conditions are different. If you decide to switch to family migration or Appendix FM spouse, the rules will change because then you are going to apply under Appendix FM to the immigration rules. So you are going to look at the rules, how the rules will change once you decide to switch to this point. But there are similarities, and we'll look at the similarities. Now, this person we are talking about met the lover. So the rule is that you have met the person that you want to marry or that you have met in person. If you're in the UK, of course, you've met the person. If the person is abroad, then you have to show that you actually travel there to meet the person. And therefore, it is not a brainer to tell you that they have met in person because they are both in the UK.
Okay.
And that is, you look at paragraph relationship with a partner, appendix relationship with a partner, paragraph RWP 6.1, met in person. Then you go to RWP 6.2, genuine and subsisting relationship.
Okay.
And we have talked about all this, and that is where the test is. It's not enough to say I have met the person. It's important that the relationship is genuine and subsisting, including the marriage itself. So how did it work? The person comes for consultation and tells that or instructs that I came as a skilled worker. When I was coming, I had a husband, so I declared I was married. I found a lover. We have been together for some time now, and eventually we are going to marry. At that time, they were not even married, so the person came for advice. They were going to marry. So fine, you're going to marry. Of course, you have to marry first before you can even try the application.
Okay.
The husband or the lover, the husband to be, had also married in the past. So she was married in the past. Husband
The other one also was married in the past.
Also married in the past. So the first thing to establish is whether they can prove that before their marriage, both of them divorced.
Okay.
Both of them divorced. So the lady could show that she had divorced after coming to the UK and skilled worker provisions. Even though at the time she was coming, she was married. Having entered the UK, marriage broke down and they divorced. This is the divorce certificate. The rules say that if you are divorced, you are free to marry. The rules doesn't tell us how long it should be for you to remarry. I tell people that is a common sense thing because if you are heartbroken, it will take time for you to heal before you go into another relationship. Just like once bitten, twice shy. So you be careful. And therefore, whether one day or 1 week or 3 months or whatever before you remarry, it's a matter for the caseworker. But we are establishing that the marriage is genuine and subsisting.
Okay.
Then the husband should also show that they have and he has separated. So how many divorce certificates do we need here?
We need two.
Two.
One for the lady, one for the gentleman here.
Exactly. Now, yesterday, for example, a client came and showed me a certificate that is purported to be a divorce certificate. After looking at that, I said, no, this is dissolution of marriage. And it's only applicable or valid under customary marriage provisions.
Okay.
And so, if you go, for example, to Ghana, under customary marriage dissolution provisions, they will give you certificate of dissolution. Certificate of dissolution. When you are married under ordinance, the green certificate, that one, it has to be divorce certificate.
Okay.
Go through the court process. Dissolution also involves court, but because it's customary in nature, you get dissolution of marriage. And so, I told this person that even though you've been given this, this is not valid because your marriage was under ordinance, not customary marriage. So you take this to anywhere, it will not be a valid divorce certificate. So the person will have to go and change it. So when the client came, so I assessed the divorce and it was valid because the marriage was under customary marriage. And whatever that the one we are talking about brought it was dissolution. So that's fine. Either dissolution or divorce, as long as it fits the context of the original marriage, it's fine.
Okay.
The same applies to the husband. The husband married in the UK, so it was UK divorce certificate, which was final order, or then decree absolute. So that's also fine. The question is, what shows that they have been in a genuine and subsisting relationship to meet paragraph RWP 6.2 of appendix relationship?
Okay.
So ask them, okay, so you've been in the UK, you divorced your previous. What was the story? They told the story, and it makes sense because she started seeing somebody. The other person gets upset and says that, you know what, I can't be with you. Families get involved. They couldn't agree or resolve, and so that marriage is dissolved, certificated. After all, I'm here and you said because of this, you don't want me anymore. So if you have divorced me, I will go ahead and enjoy my new relationship. So she goes ahead to enjoy her new relationship with a view to even consolidate it by consummating the relationship, the marriage. So they marry. Prior to that, they were living together. So when she realized that the marriage with the other one is broken down, they separated, and she was living with this new boyfriend. They were living together. And so, in terms of living together or being in a relationship, they had a lot of things to show. Communication record was there, evidence that they had been going to places together was there. It's not just the photos, but also documentary evidence. Then, evidence that they are living their lives together. um, Bank statement, separate accounts, and also joint accounts, things that were in their joint names, such as insurance, life insurance policies, and so on and so forth. So she brought all of them. I assessed all of them, and I said, at this point, we can put in an application that must work.
Okay. Before you go on, let me come in here. You know the evidence of communication. Um, People living together probably having addresses or their names both on a particular utility document. So if I do not have names on the address, for instance, but I have WhatsApp messages I can screenshot. I have text messages that have come in. I can screenshot. Can I print all those as part of the evidence that I need to gather?
If you say um, something you have screenshot, and you mentioned, for example, water bill, right?
Yeah, WhatsApp, yeah.
Water bill, are you screenshotting just the bill, the date, without the name and address?
No. I was referring to WhatsApp messages.
Oh,
WhatsApp.
WhatsApp messages. Oh,
Yeah.
with WhatsApp messages, we usually don't have to screenshot. There is a way of downloading all the chats
Okay.
from whenever. And for me, I want to see two things: the individuals involved.
Hmm.
So you are Kweku, I'm Charles. Imagine the two of us are going in as um, husband and wife. How do you call me? And how do I call you?
Okay.
I won't call you Mr. Kweku because it doesn't make sense to call your lover Mr. or Madam
Mm.
or this. It doesn't make sense, does it?
Yeah.
That
At
is
least
artificial.
in relationship, people have pet names and familiar
Oh,
names they have. Yes.
so there are certain things when people bring it to me, I say, no, this is artificial. It doesn't make sense that you're calling your husband Mr. So and so. That's the name you have saved. So the name you have saved, which is the name you used to call your lover, and the name saved for. So once you do once you download the text, you will see the names there and all the conversations and the date. That's all.
Okay. All right. So then you would have shown evidence of communication. You probably have shown that you live together or you are in touch in the lives of the other. What next would you need to provide for those applications to start and be successful?
Thank you. So let's establish the relationship component. We know that the law changed and to the effect that if you are in a relationship, you don't have to show that you've been living together. You just have to show that you've been in a relationship for 2 years. But the example we have, our case or case study client, they had not been in a relationship for 2 years. And therefore, she could only show that they married even though the relationship is not up to 2 years, they have been in that marital relationship for that period. So if you are going to show marital relationship, you have to provide a marriage certificate.
Okay.
If you are not going to show marital relationship by just saying that you've been in an unmarried partnership, then you have to show relationship for 2 years. How do you prove relationship for 2 years where there is no living together? Then you have more to prove. But most of the people, it's likely that at a point they live together. And so there will be evidence that proof of address for A, proof of address for B, the same address.
Okay.
So the same address linked to both of you. Even if it is not joint, we bring the husband works and the lady was also working because as a skilled worker, you may be working even 20 hours or full time with your employer. So there will be proof of address because the lady had already started living or moved in with the new lover, her address had changed to the new lover's address. The new lover already had a lot of evidence to prove because the new lover was living in the UK and working, living his life, of course, settled with indefinite and then British citizenship. So either settled or British citizenship, or even if it is pre-settled, you have to show that there is marriage in there or that relationship. The lady also showed bank statements, the same address, pay
Okay.
slips, the same address, utility bills, the same address. The tenancy agreement was in the husband's name. Fine. You don't have to be, because if the tenancy is already um, signed, once your husband or wife moves in, the landlord is not going to change it for you until renewal. So it
Okay.
was only under the husband's name. So that's fine. It's not a big deal. But we put all together and put a case that together, explaining the context, what happened to the first marriage, how this became, when they met, and where they are, and the plethora of evidence pointing to the fact that one, the marriage is genuine, and two, they are continuing to live as husband and wife.
Now,
So,
in a situation where uh, the new partner is outside of the UK, what will happen? Do we have to go through all showing all these evidences before the application is put in?
so if you say new husband, okay, new partner is in the UK, are we talking about a sponsoring partner, or we are talking about the partner who is
The,
being?
the sponsoring partner is in the UK, and the dependent partner will be outside of the UK.
All right.
I'm switching from that route to it might not probably apply very well, but I'm looking at a situation where we had the update to say that you can bring your partner in when you are on a skilled worker route, and I am in here and I want to bring my partner, so I'm switching from a skilled worker route to a partner route, or a family one, or spousal one, so to speak.
Well, I'm happy to tell you that both have worked.
Okay.
I have a client who called to say that, oh, lawyer, I'm in now. I'll come and say hello at the office. The wife was a skilled worker.
Mm-hmm.
The wife came with a husband, dependent partner. The marriage broke down irretrievably. They
Mm-hmm.
divorced, and the Ghanaian divorce procedures rules. The wife remarried an old lover. The old lover in Ghana, they had met before. So meeting in person had been established.
Mm-hmm.
This one, they came back to ask, please prove that the marriage is genuine and subsisting, and they had met before. So I sent back the evidence I had given to them, that I have already given you the evidence, but just so it helps you, this is it. You say that you want to prove that they have met in person. These are the photos, husband, wife, with even children of the lady who is in the UK.
Okay.
So they've met in person in the photo. The next one is that the genuine relationship. The husband had sent money to the wife to buy a car because the employer was asking her to get a car. So there
Okay.
was bank transfer from Ghana to the lady's account in the UK. I
Oh.
took that and established that who or which who I haven't come across a man, if not for good reason, will transfer money to a woman in the UK to buy a car.
To buy a car, and that will be a lot of money because you have to
The
exchange a
salary,
lot
of
of
course, was
Ghanaian
about two
cedis
thousand
into pound
pounds.
sterling.
Yeah, £2,000. So you see, this is a husband who cares about the welfare of the wife, and so blah blah blah. I ticked off. Also, the communication. They had land together, landed property in Ghana together, registered as evidence. So if this is not a genuine and subsisting relationship,
What
why
else will
all
be?
this? And it's not the case that it was then and that's it, up to the point of the application. So live evidence, the communication. So even if the communication, WhatsApp communication is not enough, the money transfer. For this one, there wasn't money transfer, and the reason was that the man is well-to-do, and so the woman didn't have to transfer money to the man in Ghana. So there was no money transfer, but there were other evidence. Even though the evidence were not a lot, we had to establish the fact that it's not about the quantity of evidence, but the quality of it and what it is seeking to prove.
All right.
But today's conversation is not about somebody who has divorced a partner and wants to bring another partner and a skilled worker. We are looking at somebody who is here as a skilled worker and one has found a husband or a wife and is switching to spouse.
Okay.
And so the evidence that you would put together if you are marrying or being sponsored by your wife or husband is what you have to prove. 29,000 is important. You have to show that your sponsor or yourself or both of you have financial evidence pointing to 29,000 gross. So I took all the evidence assessed and it was enough. The husband was more than 29, the wife was less, but put the two together is more. And so that is also established. I'm also happy to tell you that there's another application that is pending the same principle, switching from skilled worker to spousal application under Appendix FN. So these are the things that work, and that is what we are sharing with the community.
It works, and the strategies are being used by BWF solicitors, and that's the more reason I keep asking you to speak to BWF solicitors. Call them on 0208 493 7340 0208 493 7340. You can also text the emergency number 077 127 884 077 127 884. Or you can call Lawyer Charles directly 07947 636 037 07947 636 037. BWF solicitors are trusted partners when it comes to the law, and they give us the opportunity to learn and also know what there is that we have to know as far as updates are concerned. They work Monday to Friday between 9:30 in the morning and 6 o'clock in the evening. They are on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. If you're coming by public transport, get on the Victoria line, get off at Seven Sisters, second exit. That will bring you straight to the entrance of the Anna House. Climb up to the 4th floor and you find BWF solicitors. BWF solicitors, we're so grateful. You give us the opportunity to have the community and the law program every Saturday afternoon as we're doing right now. Let's say a thank you and we'll be back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back and thank you for sticking around. I've seen that somebody's joined the family on social media platform on Facebook, for instance. Wumpini, you are there. Rukia, although you're watching with us, but there's Nana Adu PSA. Nana Adu, please like the page, subscribe to it, and then share it for us as well. Well, we're discussing the switching from a skilled worker route to the family route and getting it right the first time. Laura Charles Asma is sharing an experience, in fact, two pieces of experience that he has had getting people getting it right the first time. And he's taking us through that. And I'm inviting you to talk to BWF solicitors and they'll help you. Now, if you are having any question to ask, the lines are active now 0208 493 7345. When you come on the line, please just lower the volume of your TV set or your computer and speak to us on the phone. Last one, we have somebody already on the line, so please, with your indulgence, let's attend to the person now. Okay, hello.
Hello, good evening, Orakuni and lawyer.
Good evening, madam.
Pastor, I'm what to say.
Yami Adumboko now, sir.
Yes, Adam Patton, so you pa.
Pato my intio, lawyer to you.
Pastor, my question is send me crack the ball. And I'm a man no back who crack from her book on the back of super Italian book.
Okay.
Now, me near a Republic of Ireland. Now, me pursue a coho. Me crack the ball no. I was a medivisa and I said, me pastor, send a what's a million. And my second question, this is a bit so cool. I didn't buy you for 2.5. You visa no. What's the way you be an annual pass away you be?
Okay, just our dear friend is asking that she has indefinite leave to remain. One of her children is British, and the other one has an Italian passport. And what she's asking is, if they want to visit a relative in Northern Ireland, she having the indefinite leave to remain, does she have to go for a visa before they travel to Ireland? And the second question is the e-visa bit. Somebody has 2.5. Does the person have to open an e-visa account? Last one.
Yes, if you have 2.5, you have to have it linked because the card is expiring 31st of December 2024. So the second question, the answer is yes.
Okay.
They should go through the e-visa process. The first question is about, I want to visit Ireland. Can I go? I have indefinite. I don't know how she got the indefinite, whether under EU, based on the British, based on the EU child, or under British rules, based on the child. Ask her for me. Is it settled state?
But you're saying, quite person indefinite, no?
Pastor, not me,
Yeah, a partner of a EU national.
But yes, is she still living with the husband?
What does know?
They
are divorced.
So so the rules are that if you are traveling with your EU sponsor, the EU sponsor will vouch for you that they are traveling with you, so that's fine, you are covered. But if you are traveling alone, you need a visa to that EU country.
Okay, so in her situation, they have divorced, so then she would have to have a visa. She have to apply for a visa to travel to Northern Ireland.
Yeah, so the fact that the husband is not traveling with her, she's traveling alone.
Yeah,
and she needs a visa to travel alone.
Okay, in terms of also with visa, why?
Okay.
Obey a visa to be.
Right. I mean, she has EU. Hers was based on EU. It's not permit. It's card, residence card. So she's fine.
Okay. What are you fine? Why?
mpakyɛ yi ne meda ase pa nyame nhyira mo.
I mean, shows 0208-493-7345. Lord, tell us, we have another person on the line. Hello?
Hello.
Yes.
Good evening.
Good evening.
Kune, Lawyer Charles.
Yeah, good evening.
First of all, I want to thank you for, the work you are doing for the community.
Thank you for being there for us as well.
Yeah, I want to ask this question on behalf of a friend.
No problem.
This friend I've got 2.5 partner, 2.5 parent route.
Okay.
2.5.
Okay.
And usually when he's renewing his visa, he pays the immigration health surcharge.
Okay.
Now he has got a job with the NHS as a bank staff. He wants to know if when he's going to renew next time, he has to pay the NHS, because he said someone told him if you are with the NHS, you don't pay the immigration. So I just want to know, he got a job about 3 months ago with the NHS as a bank staff. Okay. So that's what I want to, yeah.
So the obvious question is NHS staff, whether bank staff or permanent, are they exempt from the immigration health surcharge?
Yes, there is a provision that covers such people. Normally, this is how people go about it. They will make application and later go for a refund of the IHS fee.
Okay. So yeah, he may have to pay and go for a refund.
Oh, okay.
Okay.
No, he hasn't done the application. He's trying to renew the visa in the next maybe 4 months. So that's why I'm asking whether he will pay the immigration health surcharge.
I think ideally you may have to pay so not to delay your. He may have to apply so not to delay his application and decision. Then he applies for a refund.
Oh, okay. Okay.
Yeah,
Thank you.
Hold on. Charles wants to say something.
Yeah, so let our caller know that when you are applying for renewal, you pay IHS. They will ask you, are you exempt from IHS? It's not a question, are you exempt? Do you have a fee waiver? If you don't have a fee waiver, you have to pay the IHS. So you pay IHS first before you even pay the visa fee. Okay. What it means is you may have to then go to them, tell them, give me a code, so that when I get to that point, I can put it in to show that I am exempted. That may be complicated. So people will pay and later go to them to tell them that I have paid. Give me a refund.
Okay. All right. So I think possibly the most sensible thing is to pay and go for the refund so you don't delay your stuff. So yeah.
Oh, okay.
Yeah, my brother. Okay. Yeah, I think I would advise.
Thanks so much.
I would advise you.
Thank you.
Thank you very much as well. If you want to call us, the number is active 0208-493-7345. Yes, there are some questions on the platform. We can pick some of them. Balfour Kantankrachi says, I'm a spouse on the 5-year route. I'm due to apply for indefinite leave in October. However, my wife went to uni and just completed and has a job offer from NHS as nurse on a £28,000 a year due to commence in October. Her income over the last 12 months is, however, less than 18,600. My income is over 25,000. Would her income over the last 12 months be less than 18,000 affect her application? So what you're trying to say is there's a prospective source of income. Previously, she was earning less than 18,000. This is a partner. He earns over 25,000. Can they put things together so that she would meet the financial requirement?
Right. At the end of the day, it's combined income. If you are living with, but the wife has 28,000. This is indefinite leave to remain application. We're under indefinite rules. You have to show that you've done the 5 years. You have to show that you are still with the spouse. If your spouse sponsored you up to this point, you have to show that you've been living in the UK. In terms of money, how much and all that, it's not um, it's not so much of an issue for indefinite leave to remain. It's much the case if you are going for renewal of the 2.5 years. So our brother who is here, even if anything, the wife has got a job. If anything, he's also working and put together is enough. So he should be fine.
Yes, you can send your text to 07399208468. WhatsApp on the same number 07399208468. Or you can call us on the studio line 0208 493 7345. Or you can leave your questions and comments in the comment section down below, both on Facebook and YouTube at BWF Solicitors and at BWTV. Now let's pick another one we would have on there. When does one qualify for indefinite leave to remain as an EU family member? Is it 5 years from the date of marriage or 5 years from the date of arrival in the UK? This one from Junior Agenda Lawyer.
Right. So it's usually 5 years from the date of marriage, the date you became a family member to that person.
Okay. Right. So yeah, the date from which you became a family member, and that starts from when you were married. So that's a very straight answer for you. Thank you very much. Keep them coming through 07399208468. Call 0208 493 7345. Lara Charles Asma is here. This afternoon we have discussed switching from skilled worker visa to family visa or the spousal route, how to get it right the very first time. Ruka Odoy, thank you for staying with us and watching with us. Sandra Fraser, thank you for doing the usual by directing people to the right source. We are at BWF Solicitors on Facebook, BWF Solicitors on YouTube, and at BWTV, both on Facebook and YouTube.
So, Brother,
yes.
So just to buttress the point for our brother, I think if we look at the second part, the last sentence to the question, it says, no, not this one, the EU.
The EU one.
Okay, from the date of arrival in the UK. So let's assume that this person was married to this EU person for 3 years before they came to the UK.
Okay.
And they arrived with 6 months, applied for 5 years within 3 months of arrival, and they were given pre-settled 5 years. Are they going to take advantage of the 3 years that they spent abroad, or it is when they were issued or when they arrived in the UK? So there are two categories of people in this, and this question is very important. There are people who were married in the UK and later applied for pre-settled. It took some time for the application to be decided, and so by the time they got the 5 years, they had already been married together, living in the UK for, let's say, 6 months or 1 year. And so for that person, it's residential, it's based on residence, because other appendix, EU paragraph, EU 14 or EU 11, EU 14 says if you haven't been in the UK for 5 years, you'll be given 5 years. And EU 11 says if you've been living in the UK or been resident in the UK for 5 years, you'll be given indefinite leave to remain. In terms of that test, we can't say that the person, though married abroad, lived abroad, and came to the UK for less than 5 years, they will be given indefinite. So they have to then wait for them to be 5 years in the UK, resident in the UK, then they can apply for the indefinite. So those are the differences.
Well, Junior Agenda, thank you very much. So let's keep picking up your calls. Let's keep picking up your comments, and let's see what lawyer would give us. Solomon says, how does the accommodation requirement differ between skilled worker and spouse visas?
I suppose this is about a partner, be it partner under skilled worker or partner under appendix FM. Accommodation is important, and it's across every visa route anyway. and this is under the Housing Act of 1985. If you look at Part 10, it tells you that the government seeks to avoid overcrowding in residential properties. And so there is a rule. And that is why living rooms count toward bedrooms in terms of where you can sleep. So if you live in one room, one bedroom with a living room is two rooms. If you have a husband, only you don't need more than one because you share one bed, so the same room. But if you have children, that is where we look at how many children, their ages, and then how many rooms you will need. So accommodation applies to both. It doesn't really matter which visa category.
Right. Let's keep your comments coming through, both on Facebook, YouTube, and on text. 07399208468. If you have any other one on the comment section, let's pick that one. What happens to your right to work in the UK when you switch from a skilled worker to a spouse visa? Aaron?
Right. So this from our sister Angela. What happens to your right to work in the UK when you switch from a skilled worker to a spouse visa? I mean, switch means a transition. So your right will follow you.
Okay. That's straightforward and very reassuring, lawyer. We have one on the chat from one of our texts, and it says, "Lawyer, I'm here in the UK on the skilled worker route as a care worker. As of now, I still don't have a job. I've met an EU person and we want to marry. I'm having issues with my previous partner. I want to divorce him. Can I divorce and remarry, and will it affect my skilled worker visa?"
So this person is a skilled worker. We don't know whether it's a partner, but it says a skilled worker as a care worker. So this is the main person, isn't it?
Yes, I guess so.
Yeah, the main migrant. And as now, I don't have, well, we're not even going to talk. You are not doing this because you don't have a job. You are doing this because you need to do that. And so I have met an EU person and want to marry. So this person has found new love. I am having issues with my, and that is why. So you have found new love because there have been issues in the previous marriage. It is not because of the job. Or if it's for the job, then we say that are you going into the marriage because you want to have an escape option? You are going in because you want to have a sociological life, which is somebody who can understand you and live with you as a human being. And that is the new person. So if this new person happens to be an EU national, you have to show that you've divorced your previous partner. Can I divorce and remarry? We said that there's no law in the world, and for that matter in the UK, which says that if you are a divorcee, you cannot remarry. So, if you're divorcee, you can remarry. The question is, what is the purpose of your new marriage or remarriage? Is it for visa or for new marital relationship and life? If you can prove that it's for new marital relationship and life, then you should be granted a new residential status if you are going to use your new husband, that is your EU partner, to apply.
So that it means that if this one goes through and is successful, then this lady would forfeit her status as a skilled worker and become a spouse of an EU national, and will go through that route.
Yes, I mean that is more or less set in stone because there's no way anybody can have two visas running. You either have this or that.
Or
And so
that.
if you decide to switch from this before it expires to family route, which is the conversation we are having this afternoon,
Mhm.
once you are issued with family visa 2.5, you now have visa 2.5 under 5-year route, not EU, on under 5-year route, not skilled worker anymore.
Okay. So if this new found lover was a British national with a British passport, fully settled, uh, how many years would this person go on? Is it a 5-year route or the 10-year route?
We say 5 year. Well, I mean, 5 year is always under FLRM marriage. So with this, you always apply another 5-year route. You do 2.5, 2.5. Now, if the person whether the person is EU settled status or the person is EU pre-settled. Of course, there are things you have to, conditions to meet if it is under pre-settled, the person has pre-settled, or the person has British citizenship. The most important thing is you are establishing that your spouse, who is going to sponsor your application, can do so because of their status.
Okay.
And you are applying based on meeting the criteria 5-year route. If you can't meet the criteria 5-year route, you may be considered under 10-year route. However, you have to prove that a refusal will be consequential and will bring untold hardship for you and your spouse.
Okay. Well, if you still have any question, any concerning comments, please drop that now quickly, because I think after the next one, we will be going back to the question and the scenario I gave you earlier on. We have an advice to give to the couple who are in that case. Can you apply for a spouse visa if you are currently on a skilled worker visa but not yet married?
So, so applying for a spouse visa if you are currently on a skilled worker but not yet married.
Yeah.
So this is somebody who is asking whether I can apply on the basis that I'm in a unmarried partnership with somebody. Is that? I think that's the question.
Yeah, that's the question. So, on a skilled worker now here, finds a partner and is asking, can I apply for a spousal visa?
So let's do the mathematics. We know that the rules say that apart from marriage, you must prove 2 years relationship.
Mhm.
Yes.
So they can.
So if you have to prove 2 years relationship, our question is, how long have you been in the UK?
Okay.
So that you have a relationship with somebody in the UK, though you are not married, but it's lasted for 2 years.
Okay.
Because the person who is going to sponsor you, I'm sure, is in the UK.
Obviously, I guess.
So have you been in the UK for at least 2 years? If yes, then we can work out the evidence covering those 2 years. What it means is that, let's say the person has never been married, so there's no need to show divorce. But if they had been married and they came to the UK, that means as soon as they entered, the marriage broke down and they started a relationship. The other one, they've divorced that person, and so they are relying on marital relationship. I don't know how long the person has been in the UK, so it's something that needs comprehensive assessment to see if he can apply without marriage.
And with that, I would want to invite people who have further questions, people who need further clarifications, get in touch with BWF Solicitors. The numbers are on the screen below: 0208 493 7340. If you are in Ghana and you want to contact the Ghana office, 055 589 5959. The emergency 077 127 61884. Laura Charles Asma is on 07947. Let's put that one on the screen for people as well. 07947 636 6037. 07947 636 6037. Now, my question. Let me go to the scenario. Remember, we had the nugget and we're talking about where your marriage is not a marriage. Amma Grace and Kofi Brookman had a religious wedding at Aquinas Charismatic Church at Cricklewood, London in June 2015. Cricklewood, that church is on an unapproved premises under the Marriage Act. There was no additional civil element involved, and the place of worship was not registered under the Marriage Act of 1949. They subsequently had 2 children and bought 2 properties together. In January 2023, Amma filed for divorce and financial settlement order under the Matrimonial Causes Act. Please help me. I have 3 scenarios and I want us to pick one to advise Amma whether her application will succeed. Is it 1, As Amma was married in a church, she can file for divorce in England. 2. As Amma's marriage was conducted in an unregistered place of marriage, the laws would not recognize her marriage as valid, so she cannot file for divorce. Or 3. Amma can make the application because they have 2 children and 2 properties together. Now, let me help you. Let's go back to the nugget and see what the Supreme Court said. Religious marriages or ceremonies are only valid if they comply with the strict requirements of the Marriage Act of 1949. The Church of England is the only religious body whose own buildings, ceremonies, and celebrants are automatically qualified to create and register opposite-sex marriages. There's an interesting scenario here. Maybe I'll ask lawyer before I go for the break. All other churches and religious ceremonies must involve an additional civil element, and the place of worship may have to be separately registered to celebrate valid marriages. Attorney General versus Atkan Khan 2020 case. Lawyer, the Church of England is the only religious body whose own buildings, ceremonies, and celebrants are automatically qualified to create and register opposite-sex marriages. Now, this is us in a situation where now we have same-sex marriages. Do they not qualify under this?
We haven't mentioned same-sex marriage, have we?
No, it says opposite-sex marriage.
Opposite-sex marriage is the standard, the default marriage.
Mm-hmm.
Man and wife, man and woman.
Mm-hmm.
So Church of England can marry people who are man and woman. Of course, today people go beyond man and woman, so we now have man and man, woman and woman.
Mm-hmm.
But we are looking at a standard situation or default position. There are, if for example this were to be man and man, we want to then ask whether the law qualifies Church of England to officiate man and man.
Yeah, that's a question that just crossed my mind when I was going back on it.
Is that your question?
Yeah.
Well, in this case, if, for example, you bring marriage certificate from Church of England, man and man, woman and woman, and you are going to use it for family dispute, or you are going to use it for immigration dispute, somebody can contest that under the Marriage Act of 1949 and even Section 11 of the Matrimonial Causes Act of 1943, it does not make provision for man and man, woman and woman. And so the marriage may not be valid if it's not proven beyond. Because Church of England, though, has default advantage, that advantage is defined.
Well, and that will be a job for the lawyers to do and argue out. I'm taking a break. When we come back, a very, very short one. When we come back, I will find out what your answers will be, and then lawyer Asma will help us unravel it. Then we see which one will be correct. Then we'll draw the curtains down. It's still the community and the law. BWTV, and we live on the community and the law. But for Katankrechi, you said your question it was answered. Maybe you may have fallen in attention, but you can go back on the video playback and you can have your answer. Lawyer rightly answered your question. But if you still have any issues, please, you can text it back on 07399208. And lawyer will help you with that. So Amma Grace and Kofi Brookman, their scenario. What is your answer? Let's advise Tano Benson says 3. Even though the wedding took place at an unregistered place, the two came to an agreement to raise a family and as a result, bought children and made properties over the years. So she could file for divorce. That's your opinion. Thank you, Benson. You should be a pocket lawyer somewhere. Aspire Jojo Poku, I'm not sure she can file for divorce, though as a marriage is not recognized, but I believe she'll be able to make a financial application because of the children and the properties they bought together. So Aspire Jojo Poku says it's number 3. Ama can make the application because they have 2 children and 2 properties together. Henkel upon is saying number 2, as Ama's marriage was conducted in an unregistered place of marriage, the laws would not recognize her marriage as valid. She cannot file for divorce. Rabna Oba Pakunedu Yadom, number 2. Okay, so you agree with the previous one. Yawin Team says number 3, Ama can make an application because they have 2 children together and properties as well. Okay, Yanti, thank you. Charles and Mary, number 2. Next, let's see who else has come up with. Yaya Yusuf says number 3. Thank you, Yaya. Tilly says number 2. As Ama's marriage was conducted in an unregistered place of marriage, the laws would not recognize her marriage as valid. She cannot file for divorce. Okay, let's see. Okay, let us smile. For time, let's see what the answer would be, the correct one. So to speak, and then we can draw the curtains down. Lawyer.
Thank you very much, Rakoku. So there are 2 dimensions to this. Somebody came to say that, but if they fought together to build together, why would they not share together? The one you said might be a pocket lawyer somewhere. He has a point to an extent, but that is different from the conversation for today. But I'm going to address both with a view to answer this. So thank you to those who have expressed their views. The law is clear. This is somebody who is filing for divorce. So want an order for divorce and also order for financial settlement. Financial settlement deals with post-divorce matters, how the properties will be shared. And we are told that they own property together. There are children involved here and there. Question: can we have divorce without marriage? Bracket, can we have divorce without marriage?
No, you definitely have to have divorce because
Can we have
if you're not married, how can you divorce?
Exactly.
Yeah.
We can't divorce if there's no marriage. So the question is, was there marriage in the first place? If it turns out that the marriage is not recognized and therefore it is void ab initio, void from the beginning, there was no marriage. So if there's no marriage, on what basis are you going to court to dissolve that which is not there?
It makes sense.
Divorce application will fail.
That's
Number
right.
1. Number 2, because divorce application fails, the next question will be whether there will be financial settlement post-divorce application to be entertained. So the court cannot then entertain financial settlements post-divorce matters. And so strictly within the law, Section 11 of the Matrimonial Causes Act 1973 and the Marriage Act of 1949, if there's no marriage, there cannot be divorce. And so our system may not bring action, and therefore there cannot be a divorce order. It will then affect the financial settlement. What can she do? Maybe she can go to our brother who said that, hang on, they fought together, they built together, they should benefit together. And that would be a civil or common law platform under what we call trust. So under trust law, because they build together, they must share together, whether there's marriage and divorce or there's no marriage and divorce. And that would be constructive trust. There's a case law called Stark and Dowden, 2007. There was a finality. So 2007 appeal court says that because they build together and share together, there is expectation that the losing party will benefit from the estate that they built together, and therefore they should share equally. whether there was marriage or no marriage. And so these are the two platforms. So if our sister is not able to win on this platform, she will go under trust law to benefit from the property. But there's no marriage, and so she cannot get a divorce for this. And so, all right. And so our answer is 2. I can't hear you. I can't hear you. Better.
I know what my producer did. It may be considered invalid if it doesn't meet the requirements of the Marriage Act of 1949. And as Laura has explained, the answer is 2. Now, there is an article written by Lawyer Bernardo Usu and Ben, and it's on the BWF Solicitors website. That gives you a lot more explanation to that. And those of you who probably may have missed part of our discussion, you can go on to the website to read it, www.bwfsolicitors.com. It was posted on the 31st of March 2024. Our church wedding is not marriage as known under the Marriage Act 1949. So visit the website and take a read of that. You can, other lawyers, yes, you can pick up the link and make arguments from that, and also advise your clients on that. With that, I come to Lasma. Please, tradition cannot be broken. A summary for our discussion.
Thank you, viewers and listeners, for staying with us to this point. Finally, what we are saying is that you can switch. That is absolute assurance. You can. Whether it will work or not depends on what you do. But you can get it right the first time if you follow the rules. 1, you have to show that there is a relationship that is genuine. You have to show that the relationship continues to exist. You have to show that the marriage that created the relationship is valid. If it is from abroad, it is valid in that country, and therefore UK must accept. If it is in the UK, it must be accepted within the provisions of the Marriage Matrimonial Causes Act 1973 or the Marriage Act 1949 within the UK. We have discussed a bit of it within the nuggets. And so once you have done the right thing, your application can succeed. And so you can switch from skilled worker dependent to to a family spousal visa, or you can switch from skilled worker main migrant to family dependent visa. Either way, you should be able to succeed if you follow the processes and ensure that you have met the rules. The key rules are Appendix Relationship, paragraph RWP 6.1, meeting in person, and RWP 6.2, showing genuine and subsisting relationship. If it is marriage, marriage certificate plus and other documents. If it is unmarried partner, being in a relationship together for 2 years with your evidence supported. This is what we brought you today. Thank you.
Thank you very much, Lawyer Charles Asma. We're so very grateful. And to those who have been with us from the very beginning to the end, Stephen Jensu, Kofor, Tilly Duma, Bafo Katakrechi, Wumpini Adams, Sandra Fraser, Amos Abibio, Wisdom Jan, all the other people that have been online with us. Thank you very much. We're live on BWTV, on Facebook and YouTube. We're also live on BWF Solicitors, both on Facebook and YouTube. So congratulations again to our worker of the month of August, employee of the month of August, our brother Emmanuel in the Accra office. Congratulations to you. And but just a smile, let me also again, on behalf of our viewers and the BWF Solicitors family, thank you for your time. Uncle Ben, senior partner, thank you for your kind intervention and helping the discussion. To the family here in the UK, headed by Auntie Cynthia, Sandra, all the student lawyers, all the other partners, and everybody at BWF Solicitors. Thank you for your support and your admin and the research you do behind the scenes to help us have a very good discussion. To my production team, Padma Dudu and Sheila Ankra for doing the admin and the aesthetics, and to my studio producer and director, Professor Ade, who is as patient as the word. He does all the tricks, except that this afternoon he muted me at the point. But yeah, that's notwithstanding. It's been a very lively time with you. So I want to invite you to join us again, same time next week on the same platform for another edition of the Community and the Law Live here. My name is Oriku Frimpong. Good evening.